Richard.
Hi, Andrew. Good to see you.
Yes, you too.
Good to see that you, unlike me, don't have any clippers at home.
I could probably do with some, to be fair.
As long as I stay at this angle to the camera, then it's all right. But if I turn sideways, then it's you can see a couple of slips.
Yeah, and I've seen it, and you don't want to see it.
We thought it would be helpful to go through some of the practical issues that Andrew and I have come across in the last few weeks since effectively the country's gone into lockdown, touching mainly around areas related to furlough, but other things that have come up that are around that kind of area. So this will not be a webinar that goes through everything about how you apply for and how you grant furlough. We're conscious there are a lot of those around. The intention is that we're hopefully going to provide you with some helpful guidance. So very briefly, I suspect that the whole country knows this now, but furlough is a term that many probably know better as being laid off. And the government have introduced the scheme to try and help people stay in work. It applies for a minimum of 3 weeks, which the intention being that you can't just switch people on and off furlough. There has to be a genuine need to put people onto furlough. And you're able to recover up to 80% of someone's wage, but capped at £2,500 a month. So some employers, and I think probably a number of those that Andrew and I have come across, have been paying people the extra 20%. So whilst they're not working, the drag on the company is much reduced because of the 80% from the government, but in fact the employee themselves are getting the whole amount. I
have seen cases, mine, where they aren't paying the extra 20%, which is probably to be expected with some.
Yeah, and I think Andrew's going to briefly touch on the fact that that's, or I may deal with it now perhaps, that's of course a change to terms and conditions, and so it needs to happen by agreement. So if an employer tries to force someone onto 80% of their wage, that in itself could be a breach of contract, but that would all be viewed, set against the circumstances. And my own view, and I've been asked this quite recently, is that if the employer is facing a situation where either the employee is going to be made redundant or they're going to be put on furlough and receive 80% of their wage and hopefully in due course will be able to come back into the business, then that request for them to go on to 80 situation may not be something that does lead to a breach of the fundamental term of trust and confidence, and means that someone could resign and claim constructive dismissal. But that will depend on the particular circumstances. Yeah. So one more thing, I suppose, to flag from me before passing on to Andrew about how you try and look at selection processes for furlough, is very recent news on furlough is that the government has extended the period for those who are eligible for furlough up to the 19th of March now. So those who were only employed after the previous date, the 28th of February, and were employed between that date and the 19th of March are now eligible for furlough, which I understand may bring a number of additional people within the scheme. Not something which has come across my desk, but something which hopefully is of some assistance to a number of people in the country.
Yeah, I mean, I think, and what I've seen so far is perhaps the bigger issue with furlough is not necessarily about whether you're going to furlough employees, but it's about how you go about choosing those employees that you're going to furlough. Because like with any situation, it's almost down to the discretion of the employer. And where there's any case where there's a discretion, there's room for bias, there's room for discrimination, there's room for victimization. And one of the problems I'm seeing is it's really easy for employers in the current set of circumstances to think they can just jump to a quick, rash decision about who they're going to furlough without actually really standing back and thinking about it. So some of the advice I would still give, and some employers might find this onerous and it might not be reasonable in their circumstances, but they still need to go through a process. I still think they need to inform the employee of the problem. They need to consult with the employee. And that includes, I think, with respect to who should be furloughed. And I think a prudent employer would even go as far as to consult with the unions if they're a unionized workforce or if they've got employee representatives. Now, I appreciate that some employers might find that a little bit over the top, but if you're going to do this properly, a well-documented process might well help you if there are claims of discrimination or victimization made against you in the future. So I think one of the things I would be saying is employers really need to remember that. And likewise, employees need to look out for their employer not doing that. So it seems to me that one of the reasons that's important, and I'm sure you're going to touch on this, Richard, I think, is that employers mustn't forget that not only do employees' rights exist and continue during furlough, but they exist when they're deciding who they are going to furlough. Something which I think is really easy to forget, but I think you're going to touch on that, Richard, a bit more.
Yeah, no, I think that's absolutely right. And I think that one thing that we both stress is that when you are looking at furlough, particularly at the current time where the pressure on employers is very significant and they're having to make decisions quickly, one thing which is definitely beneficial whenever either of us deal with any kind of employment case is if there is a recorded, written record of the decision-making process. Far better that that's in writing now, and so that the decision that you need to furlough and the basis of selection of furlough is in writing now, rather than that it's in a witness statement sometime down the line when it ends up in a tribunal, because any judge is predisposed to being happier with contemporaneous documentary evidence than they are with witness accounts later down the line.
I think it's really important because whilst many employees in the current circumstances will just agree to be furloughed, in essence, you can't agree to be discriminated against. So I think that's really important to remember. So even when you get the employee's agreement, that might help, but it doesn't mean that it's a blanket defence to a discrimination or a victimisation claim.
And important, I think, for both, in fact, employers and employees to have in mind that all of your employment rights are still in play throughout the time that there is any period of furlough, including in the selection process for furlough. And I suppose it's in that selection process particularly that Andrew and I have had a few practical issues arise.
Yeah, I mean, I mentioned earlier about discretion. One of the big things which we're seeing a lot in the news, for example, about PPE, and I think we all well know now what the 2-metre rule is in terms of social distancing. And these are all things that employers, where you have staff having to go to work, key worker or not, these people are quite rightly interested to know that their health and safety is being protected at work. I imagine there will be employers who may not meet all of those standards, and employees are quite entitled to complain or raise issue about that. And that brings me on to one of the main points which I think might arise, is around issues of health and safety, or even whistleblowing at work, actually, because I can quite see an employee saying to their employer, well, you haven't provided me with the necessary PPE, or hang on a second, you've got an employee who keeps walking past me or is working 1.5 meters away from me here. You're not enforcing the proper health and safety rules. And there are protections for employees in those circumstances. You know, ordinarily, if there's a union or a representative committee, a health and safety committee, they should raise their concerns with them. But if there isn't, as long as that employee raises it by reasonable means with their employer, so raising it with their line manager, for example, they may well receive the protection of section, I believe it's section 44 and 100 of the Employment Rights Act. So they can't, for example, be subject to a detriment for having done that, or they can't be dismissed for having done that. And likewise, and I haven't seen this yet, but I envisage this coming. You may even get employees who say, well, I'm refusing to come to work because I believe the circumstances to be dangerous. And they're certainly serious and imminent, one might think. And it's easy for employers, I think, to see those employees as perhaps troublesome, or they're easier managed out of the workplace. But those are the kinds of factors that an employee mustn't have in their mind when deciding to furlough someone, especially if they're going to furlough them with only 80% of pay. That, to my mind, would be a clear detriment. I don't know if you've come across that, Richard.
Yeah, I have actually very recently had a situation very like that in a call centre environment. So that the difficulty with a number of call centres, of course, is that they deal with lots of incoming calls about connectivity, which is incredibly important now in the environment that we're all operating in.
Yeah.
And so I had a query where I was asked to give some informal advice where the company quite properly had tried to allow the employees to work from home, but it hasn't worked in all cases. So they've required those who are unable to work from home to come into work.
Yeah.
And they're still sitting in the layout that was the layout before all of this, which is not a full 2 meter distance apart.
Yeah.
And this particular employee doesn't sound like a disability, but suffers with anxiety. And the anxiety conceivably could become a disability because the employee is becoming more and more anxious about going into work. And in that situation, exactly as you've just outlined, it seemed to me that that employee needs to raise it with their manager. I think that had already happened. And ultimately, if it gets to it, then there is a grievance procedure, or there should be a grievance procedure in place for every at every employer. And if there isn't, then there's the ACAS code online.
Yeah.
And that employee or someone in that situation can raise a grievance about it. If subsequent to that, they're treated in a way that's negative, then all of the kinds of protection that you've just outlined, Andrew, it seems to me would be firmly in play.
Yeah, I think even employers will often have a whistleblowing policy, for example, that they might be able to refer to or consider, with or without the help of a union or a rep. But yeah, really what I'm trying to protect against is about whether consciously or otherwise, these people are being treated differently or furloughed and perhaps even suffering a 20% reduction in their pay. I'm sure that, that the same applies when it comes to discrimination as well. I think we've both perhaps seen issues which might arise to indirect discrimination under the Equality Act. I think you've seen one.
Yeah, I think that's right. I suppose really a lot of this comes back to communication, and where employers, and obviously there are time pressures on everyone in what's happening at the moment, but where employers are able to communicate clearly with their workforce, that will help avoid any of these sorts of issues coming up. But it seems to me that where it is simply a cost-cutting exercise, that furlough is, we need to save some costs because our income has gone down, then the obvious starting point is to ask for voluntary furlough, to ask people to volunteer themselves to take furlough. Once you've done that, if that resolves the situation, great. The problems all arise once you have to start selecting people for furlough. And the problems that we've both seen involve selections that may be indicative that a particular demographic of the workforce are being selected for furlough. And once that starts happening, then there are potential discrimination issues. So, for example, part-time workers who have potentially caring responsibilities, it's generally accepted that those with caring responsibilities, although the lines are probably increasingly blurred, but it is generally accepted in employment tribunals that those with caring responsibilities are predominantly female. And so if you see other working part-time hours, and there are a number of people in that situation, and they are getting furloughed, the part-time workers are getting furloughed, that could create a situation where issues of indirect discrimination arise. Yeah. Equally, where you have disabled people working part-time hours in order to accommodate their disability and be able to continue at work, furloughing all of the part-time staff could have an adverse disparate impact on disabled people. Yeah. And that could found the basis, and we're not going to, in this webinar, try and outline every kind of employment claim that you might have. But for disabled people, there is a particular type of claim called discrimination arising from disability. And if you were being furloughed because you worked part-time, and the reason that you worked part-time was that you were disabled, then that on the face of it might form the basis for that kind of claim. Now you can justify that, and there are, in the current climate, there are various things that you would think of might form a justification. Absolutely, you know. So it's a guarantee, but these are issues that, in our view, because of things that have hit our desk, are matters that need to be considered. And so, for example, if you have someone who is a single parent, let's say, with part-time working already in play, their caring responsibilities at the present time are likely to be exacerbated because, as we all know, if they are not a key worker, they haven't got the kind of protection of the child going to school during the daytime. And assuming that they are following the guidance of the government, that probably means that they're at home and they have a child to look after while trying to carry out part-time work.
Yeah.
So these are particular circumstances that need to be looked at. And I think,
sorry to interrupt you there, Richard.
No,
I agree. I think whilst we can, and I think again, this is far too easy for employers in the current climate to think that they're going to readily be able to justify something. But actually, you need to stand back a little bit here, because they would need to show there was a legitimate aim in choosing people who worked part-time to be furloughed, and they need to show that they pursued that proportionately. It all comes back to process and speaking to people, because they need to show they actually turned their mind to, well, why do we need part-time workers to be furloughed? What else, or who else might we be able to furlough, as opposed to the part-time workers who may predominantly, as a general proposition, be females or disabled persons. So again, I think it all comes back to what we said at the start. It's about exercising a discretion, but exercising it with a bit of thought and a bit of communication, which not everyone does.
I totally agree, and I suppose also back to get that down in writing, have it there, have the evidence there. And the other thing that came out when Andrew and I were discussing this when we were thinking about this webinar is that goes wider than furlough issues, really. So in the current circumstances, it is entirely possible that more flexible working requests will be made. More requests to work less hours than the full contractual hours will be made. Or I suppose, unfortunately, not only will there be requests for care, time off to care for dependents at the current time, but also bereavement leave will be asked for.
Absolutely, yeah.
So all of those things are firmly in play at the moment. Each one of those probably needs to be, I think we would both say, dealt with on their own facts.
Yeah, I mean, I agree. And the other category which I have thought about, I haven't yet seen a case on this, but I've thought about pregnant employees who have the right not to be subject to unfavorable treatment for being pregnant or on maternity leave, or indeed proposing to go on maternity leave. You may have many pregnant employees who wish to still be at work. It would be wrong for an employer, in my view, to think, well, it's easier or it's safer, it's better for us not to have a pregnant employee in the workplace. We're going to furlough them and reduce their pay. I think that in itself might actually lead to a Section 18 claim under the Equality Act relating to pregnant employees. But it just shows how many ways there are, it seems to me, for an employer to potentially get this wrong. If they're going to jump to conclusions, which they perhaps shouldn't be.
Yes, it's. I suppose, to be fair to any employers who are watching this, we all, I think, probably recognise it's something of a minefield in an area that's new and developing. I suppose one example. It's not exactly on what you're saying, Andrew, but I agree that is firmly in play. Is the kinds of issues that surround concerns about redundancy. And I had an inquiry from someone who was due to be coming back from their maternity leave. And they were concerned, and voluntary furlough had been asked for, or volunteers for furlough had been asked for. And they were concerned that putting their hand up for furlough would mean that should there be a redundancy exercise later on, that would mean that they were at the front of the queue for a redundancy. And given that they had been through OML into additional maternity leave, they were in a position where they really needed to start earning some money again through wages. And I've had that inquiry from the person who was due to be coming back from maternity leave, and a similar inquiry from someone about whether, if they're put on furlough, that means that they're more likely to be made redundant should the upturn at the end of all of this that we all hope for not happen.
Yeah.
And it seemed to me, and I'll let you give your view on this in a minute, but it seemed to me that the key for all of that was the terms of the furlough. So in both cases, when I got them to send me the documents and I looked at the documents, it was made clear in the terms of the voluntary furlough scheme, in the case of one, and in the other one in the selection for furlough, that was not something which would be held as any kind of factor should there be any subsequent redundancy exercise.
Yeah.
So as long as that's there and it's expressed, and if it's not expressed, of course, the employee can ask for it to be made express, then it seems to me if you then subsequently were to try and rely on the period of furlough in a redundancy exercise, you'd probably be trespassing into unfair selection territory.
Yeah, I'm inclined to agree with that. I mean, I think I would actually add to that, Richard. It's even a bit unclear at the moment, to be honest, in some of the more recent guidance on the job retention scheme, whether or not actually having a redundancy situation or a possible redundancy situation in play is a precursor to being allowed to furlough people and benefit from the scheme. There's even been a change, for example, to, I believe it's with respect to shielding employees. There was wording about you can furlough a shielded employee if they were otherwise going to be made redundant. I'm paraphrasing, but they've removed that. And I do think it's a bit up in the air actually still, whether or not there needs to be a redundancy situation at all in order to benefit from the scheme. So I think that's relevant to what you're saying, perhaps even your client.
Yeah, absolutely. And I suppose there are people who have left employment within the period that will now run into March, who are eligible to ask to come back to their employer and be furloughed rather than leave employment. And when I've been asked that kind of question, the key to me has seemed to be, well, why did they leave? If they resigned to go elsewhere, then really that was the reason that they'd gone. Equally, if you've dismissed someone for a conduct reason in that period,
Yeah. I've seen that. Actually, yeah.
You've actually had that on your desk.
I've had that inquiry.
Yeah, it's difficult to see in that situation why you should be re-employing that person and furloughing them, because the conduct reason is the reason that they've gone.
I'm inclined in those circumstances to agree with you on that. I think I'm not sure how HMRC would look at you actually if you had sacked someone for gross misconduct or for some other reason, and then all of a sudden you've re-employed them and that you're looking to gain the benefit of the 80% from the scheme. I think HMRC would look a bit dimly on that actually.
I think in those situations, the government's view is likely to be that those people should be looking towards the benefit system rather than the job retention system, because the point is you're supposed to be retaining jobs rather than giving people who've left employment an additional
and it's about protecting those where businesses are severely impacted because of COVID-19. So I suppose if someone's been dismissed for misconduct, I'm not sure that I see the connection there with the impact on your business as a result of COVID-19. So I think that there might well be a challenge to that. And of course, if there isn't a challenge at the first instance, the worry becomes, what happens if HMRC give you the money and then find out you actually shouldn't have gotten the money? It's all very unclear what HMRC is going to do actually to enforce the rules of the scheme. So I think that probably goes to show, Richard, why it's all a bit up in the air still, but why there are some potential problems or knotty issues, I think we've called them, between us, which can arise between employer and employee. And as Richard said, I don't think we can ever sit here and give you any blanket advice, and I don't think we purport to, Richard, do we?
No, I mean, I suppose one final thing to say is, my view is that furlough should be either a redundancy situation or a COVID-19 related reason.
I agree.
And just on the redundancy issue, if the selection for furlough is on the basis of selection criteria that look like redundancy criteria, then you need to be very cautious in that situation.
Yeah.
And you would want it as an employee and indeed as an employer, if that was not something which could have an effect on a subsequent redundancy exercise, say that you come back and your turnover is adversely affected by all of this. I think you'd want that to be clear on the face of the documents, because not only would the person who's been furloughed be very nervous about what happens in a subsequent redundancy exercise, but if someone wasn't furloughed and they knew that someone who had been furloughed on a similar exercise had scored lower than them, they would probably have some issues with their selection down the line. Yeah. So again, it comes back really to communication, I suppose.
Yeah, it's all the issue we have as lawyers at this point in time is that we're working from a scheme, and even on the question of whether you need a redundancy situation or where's the threshold in order to be able to claim under furlough, it's all very up in the air. And I think you put 10 lawyers in a room, you're going to get possibly a different answer from all of them, because I think it's arguable both ways as it currently stands. So yeah, I'll pass to you, Richard, to close.
Well, I suppose we both say we hope that that's been useful to anyone who watches it. And we wish you all the very best of health. Stay safe, and we look forward to seeing you in person the other side of all of this.
Absolutely. All the best.